On this season of Love During Lockup, we have one couple, Savannah and Bradley. Savannah is 27 years old. She works as an event bartender. She lives in Virginia. She has no kids. And she's with Bradley, who's 28 years old. He's serving time in prison for transportation of a firearm. And she knows Bradley because he was her former weed dealer. Well, I looked into Savannah. I came across a few of her past arrests. She was arrested on August 15th of 2022, and she was arrested for petite larceny, less than $200, not from person. So she stole less than $200 worth of items. And if it wasn't from a person, I'm assuming she likely shoplifted from a store. I'm not 100% certain, but that's what I'm likely assuming since they said the larceny was not personal. And then I looked into her boyfriend, Brad, his arrest that ended up sending him to prison. So it says Bradley was stopped by police while he was driving, and his vehicle was searched due to the odor of marijuana coming from it. The officers found a firearm in Brad's vehicle, and he was arrested for possession of a firearm after being adjudicated delinquent as a juvenile at the time of the offense of a delinquent act, which would be a felony if committed by an adult. And Higgs made a motion in limine to suppress the evidence found in his vehicle, which was denied. And Higgs was ultimately convicted of violating code. Then they list the code number, and they said he now appeals the circuit court's denial of his motion in limine. And then it goes on to say on April 25th, the Virginia Commonwealth University police officer Quiles noticed a vehicle being driven without headlights. Okay, you cannot be riding dirty without headlights. Come on, man. And then it says Officer Quiles indicated that the driver, Higgs, should pull over, which he did. When Officer Quiles approached Higgs' vehicle, she noticed the odor of marijuana was coming from it. She searched the vehicle to find the origin of the marijuana odor. In the course of her search, she found a firearm underneath the driver's seat. Brad was subsequently arrested for possession of a firearm. For those of you guys who don't know, a motion in limine is a pretrial motion that seeks the exclusion of specific evidence or arguments from being presented during a trial. So they just feel like some information is irrelevant, or if the lawyer's trying to get his client to win a case, and he might try to file a motion in limine to try to get certain evidence thrown out that could be used to find his client guilty. So it says on June 29, 2021, Brad filed a motion in limine to exclude the evidence obtained from the search of his vehicle, mainly the firearm. Okay, so that would pretty much just throw out the whole case. I mean, she was searching the vehicle looking for weed, so I feel like she had a good reason to be in the vehicle. I don't see how that's considered irrelevant. Brad argued that this certain code prohibits stops, searches, and seizures solely on the basis of the odor of marijuana and requires the circuit court to exclude evidence discovered or obtained in violation of the statute. Okay, if he did this all himself without a lawyer, that is pretty impressive. And then it says, barred the Commonwealth from using any evidence resulting from the vehicle search. The Commonwealth conceded in the circuit court that the search of Brad's vehicle was based solely on the odor of marijuana. The circuit court denied Brad's motion in limine to exclude the evidence that resulted from the search. The circuit court declined to decide whether the code was substantive. Okay, why can't I say that word? Substantive. I know how to say it, but for some reason my mouth's not letting me. Or procedural, stating I don't think I need to get there and I'm just going by the law in the books today and it hasn't been violated. On October 8th of 2021, Brad entered a plea agreement where he pled guilty to possession of a firearm by a non-V felon, but preserved his ability to appeal the circuit court's denial of his motion in limine. The circuit court sentenced him to 5 years incarceration with 2 years and 6 months suspended. The appeal followed. Brad also filed a motion to suppress the evidence, in which he argued that officers asked him questions without giving him his Miranda rights, and the circuit court denied Brad's motion to suppress on Miranda grounds, and he does not appeal that decision. They found that this code did not contain the language and no search warrant may be issued. The language is not relevant in this case because, as in Street versus Commonwealth, this case involves a search supported by circumstances rather than a warrant. They used an example in another case where they said that they had the police and they had the right to search due to the odor of marijuana. So they used this example from this Montgomery case, and they said in 2018, Montgomery was pulled over by police for driving with his headlights on high beam. Very similar to Brad, because Brad was driving without headlights. This person was driving with their headlights on high beam. And when police stopped his vehicle, they smelled weed, and the officers searched the car to find the source of the odor. During the search, the police found a backpack containing marijuana, and Montgomery was subsequently arrested and indicted for possession of marijuana with intent to distribute. After his arrest and indictment, this code was amended to include subsection F, which outlawed searches based solely on the odor of marijuana. The amended statute read that no law enforcement officer, as defined in this certain code, may lawfully stop, search, or seize any person, place, or thing solely on the basis of the odor of marijuana, and no evidence discovered or obtained pursuant to a violation of this subsection. Okay, so pretty much it just explained that you can't just search based on the odor of weed. And then it says, following the amendment, Montgomery moved to suppress the marijuana found by police, arguing that the above statute prohibited its use as evidence in a criminal trial against him. So in this case, following a hearing, the circuit court denied his motion, and he appealed that decision in court. And on the appeal, this court looked into this code, which was later repealed when this other code was enacted, to determine whether it retroactively affected the search and seizure of his vehicle. The Montgomery court noted that the statute's exclusionary rule only applied to evidence. And so pretty much it just explains that the court declined to retroactively attach new consequences to a search that had already taken place prior to this code being put in place. So they're acting like what happened to Brad happened before they put this in place. And they used examples of other cases too. They explained this case from November 2019 where this street person was stopped by police because his vehicle's registration had expired, and while the police were talking with Street, a cop smelled weed, and they decided to search the vehicle, and they found a firearm. Street had a prior felony conviction and was subsequently indicted and convicted of violating a certain code. And in August 2021, Street made a pretrial motion to suppress the evidence of the firearm, asserting that this code made the search unlawful and rendered the firearm and his statements admissible at trial. Street also explicitly rejected the same argument that Brad makes here, that the code is purely procedural. And it goes on to say that the court determined that the remedy of the code was still in effect at the time of Brad's arrest. They compare Brad's case to Street's case. They say there's a lot of similarities, but they pretty much explain that the search happened before they put the statute in place. They ended up turning down Brad's motion in limine to exclude the evidence, so they moved forward with the case and included the evidence. The judge said, I don't think I need to get there, and I'm just going by the law in the books today, and it hasn't been violated. So on October 8th of 2021, Brad entered a plea agreement where he pled guilty to possession of a firearm by a non-V felon. And sorry, I have to say it that way because YouTube does not like the V word when I say it. And it says, but preserved his ability to appeal the circuit court's denial of his motion in limine. So they sentenced him to 5 years incarceration with 2 years and 6 months suspended. And that's when the appeal followed. But obviously the appeal did not work. And it appears that he just got out of jail this year. Him and Savannah are still going strong. They post together on Facebook and Instagram from time to time. But that's pretty much it for this video, guys. Let me know what you guys think in the comments below. Give this video a thumbs up, subscribe, and thank you so much for watching.